couple of minutes for people to join, and then I will get started. Okay, my name is Chuck Royer. I'm an attorney at the McCarthy, Lebit, Crystal, and Liffman law firm in downtown Cleveland. I have been practicing for 34 years and a few days. I didn't intend to be a collection lawyer when I went to law school, and frankly, I'm not, but I started doing it in around 1989 when a partner came in and asked me to see if I could help a landscape material supplier collect on an account that was unpaid. So I've been lucky enough to represent the same landscape material supplier since 1989 on an ongoing basis. I would say approximately 20 to 25% of my work revolves around collecting debts for small businesses. So in those 31 years, I would like to think I've seen pretty much most everything. I've had the opportunity to seize automobiles and trucks. I've seized large pieces of construction equipment for a debt, to collect a debt. I've had the privilege of calling a client 6 months after I did something where I recommended we do something, and out of the blue tell them that as a result of what I did, I had a check for him for $30,000, which is, you can build a lot of loyalty that way. I've also chased debtors for more than a year, and when I've seized a bank account, they called me and asked me if I give them the 20 grand back, they'll write me a check for 10 grand, which is an interesting experience. So I'm going to be happy to take questions through the Q&A app, if that's what it's called. So the title of this is Cost-Effective Collection During the COVID Era. McCarthy, Lebit, and Crystal and Liffman is a firm in downtown Cleveland. We have 40 lawyers, 70 employees in total, and we've been in business since 1959, originally starting as a firm that did a lot of work for IRS problems for people. I have been practicing law since 1986. So I have over 30 years of collection law experience and experience representing small businesses. And so we'll begin. Obviously, if you have a specific legal problem, you should consult a lawyer or call me, but you should not rely specifically on anything I give you during this presentation. So I'm going to focus today on, based on my 30 years of experience, what I think the primary obstacles are that prevent companies from effectively collecting on debts. I think in today's world with the pandemic, it's even more important that you make sure that every dollar that can come in the door does come in the door. And it's my view that the best way to do that is to have a procedure in place when a new customer comes to you to take steps to prepare against problem accounts at the beginning of the relationship. The more relevant information you can give to your attorney. The less attorney time is required and the less expenses you have in chasing a bad account. The more time that your attorney can move form filling out to a paralegal at a lower rate or someone else or a secretary, the more money you can bring in the door as a result of this account, as a result of your business. So over the course of the last 31 years, I've had a number of potential new clients call me, and I'm going to start this discussion with a screen that shows you what typically or oftentimes, unfortunately, I get. Someone will call me and ask me if they think I can cost effectively collect on a debt for them. And I ask them for an account statement or an invoice, and I get something like what is on the screen now, which shows John Smith, JS Roofing, has an address, maybe what the person purchased on credit, and then an amount due. There are a number of things wrong with the information on this screen. The main one of the principal one is that I cannot tell who actually bought the shingles on credit. I don't know if it's John Smith individually. I don't know if it's John Smith doing business as JNS Roofing. I don't know if it's JS Roofing, which is really a different name for some corporation that's been formed in Ohio that isn't on the form. And in order to collect on a debt, you need to know the exact name of the entity that you sold the materials to. This lack of information will cause an attorney to have to look at the Ohio Secretary of State website for corporations divisions to determine if he can determine what the actual name of the company is and who it is. It may be that if you use someone who has hundreds of cases, collection cases, he won't mind. But if you have someone who's a little more specific and handles maybe 10 or 15 cases for you a year, it's going to cost him time and effort. And eventually what happens is the client asks, how much is this going to cost? And because of the lack of information, it increases the costs and makes the ability to collect cost effectively more difficult for the client. What I mean is, my goal would not be to spend $1,800 collecting a $2,900 debt for you. That doesn't make any sense. And so you want to do as much as possible at the beginning of the relationship with a new customer to prevent, to decrease the cost you would have in chasing this customer if the account goes bad. So the main obstacles that prevent small businesses from collecting on their accounts, in my view, are not establishing proper procedures for when they issue credit to customers. That means obtaining key information at the beginning of the relationship. 2, not understanding when pressure points exist to get them paid. That means there may be points in the process where they have the ability to demand payment for delivery, and they should, clients should not be shy about doing that. I would also, encourage everyone to establish a long-term cost-effective relationship with an attorney. Find an attorney who is interested in a long-term relationship, treat you with respect, will return your phone calls promptly, return your emails promptly, and is willing to take a phone call that isn't always going to result in a billable hour, but means that you have an ongoing relationship for a number of years. It's good for you, it's good for the attorney, it's good for cost-effective collection. So the next screen, I'm going to show you is that I think that if you are not using a formal credit application, that you should be using a formal credit application to make sure that you have all the correct information obtained from the customer at the beginning of the relationship. And that information should be the proper legal name of the business entity and its address. If it has an EIN number, that also should be obtained. If it's an individual, you should get the Social Security number. You should also ask the client, the customer, to identify where it does its banking as part of your credit check process. So you would have the name of the bank, an address, and a telephone number, an account number, I'm sorry. And clients and customers will give you this. If they refuse to give you this, there's a sign, there's a problem. If you are in a business where sometimes you are dealing with newly formed entities and you are unsure about your ability to collect from them, I would encourage you to put in the credit application a personal guarantee for small companies that would simply state that to the extent the bill or invoice is not paid by X company, I, Joe Smith, also agree to be responsible for that bill. If it's an individual, the credit application should identify the individual's place of employment. I would also encourage you, and I know this sounds like a lot of work, but it's well paid off in the right account. If a customer pays by check, I would encourage you on occasion to keep copies of the checks so that you have a record of where they bank. And later in the presentation, I'm going to explain why that's important and how that leads to the ability to collect cost effectively, which is what you're looking for. You're looking to want to collect money without spending a great deal of money to collect that money. I would encourage you, as I said earlier, and I'm referring you to the next screen, to use, if it's appropriate and people will sign it, a personal guarantee. This is one I've used for years. It says, I put it at the bottom of the credit application, in consideration of the extension of credit by your company to blank, I blank personally and unconditionally agree to pay all invoices, statements, and any monies due and owing to your company. I agree and acknowledge that I am personally liable for this debt, regardless of whether the debt exceeds the line of credit requested by the above referenced business. And the credit application should provide a place for the customer to request a line of credit in a certain amount. And I want to point out to you the last line in the guarantee where it says, I agree and acknowledge that I am personally liable for this debt, regardless of whether the debt exceeds the line of credit requested by the above referenced business. On occasions, I've had customers who've assigned a credit limit to a client, to a customer. I've had clients who've assigned a credit limit to a customer, and because of a snafu or a foul up, they've given the customer more credit than the customer asked for. And I've actually had people in those cases make an argument that, for instance, I owe you $5,000, but you only agreed to give me credit for $4,000, so I shouldn't be liable for more than $4,000. And people do make that argument with a straight face. I've had a couple judges seriously consider it. So you want to have something in the personal guarantee that makes it clear that there's personal liability regardless of the amount of the debt or of the line of credit. Now, I'm going to try and tie this all together a little bit better. In Ohio, the most cost-effective ways, the easiest ways, the less expensive ways to do collections are bank attachments and wage garnishments. A bank attachment allows you, once you get a judgment, to serve upon the debtor's bank an order a court order which says, upon receipt of this, any money you are holding for Joe Smith Corporation must be paid to the court. And this ties to the credit application, because in order to do that, you need to know where your customer banks and the account number, not always the account number, but it's helpful to have the account number. And if it's an individual, well, let me go back. A bank attachment can typically be done by a paralegal in less than an hour. You're talking about a filing fee of around $100 to $150, and then a paralegal's time and an attorney signing off. So basically, you can do an effective bank attachment for a couple $100. And this may surprise some of you, but I've actually had circumstances where someone told me they couldn't pay. And within the last 6 months, I've had this happen. Then I did a bank attachment, and they had $20,000 in their bank account, and my client was paid in full. So there are people, or businesses, that don't respond to complaints, that don't move their money out of the account they've told you they have, where you can, for a couple $100, seize quite a bit of money. Not always, but it's the cheapest and most effective way to do collection work in Ohio. If you are given a debt, if you are owed a debt by an individual who you know is employed by a third party, you can also what's called file a wage garnishment, which you can, it's a form that the court serves on the debtor's employer that allows the debtor, that orders them to pay a certain percentage of the debtor's wages to you every time the debtor is paid. There are limits on how much you can get per paycheck, but if you, under Ohio law, if you serve this wage garnishment order once, as long as the debtor continues to work for the employer, you are going to get a check every single time the debtor gets paid, until either one, the debtor loses his job, two, the debtor goes bankrupt, or three, the debt is paid in full. But it's another procedure that for a couple $100 can be effective in obtaining money from debtors. If you don't have specific information about the debtor's bank or the debtor's place of work, collection becomes a lot more difficult. You have to typically do what's called a debtor's examination, which is you ask the court for an order to require the debtor to come to court and answer a question about his assets. It's not atypical for a debtor to refuse to come to court, and then you have to file a motion asking that the debtor be held in contempt, and then you have to get personal service. And what was a collection could be done for a couple $100 becomes suddenly you've spent $1,000 chasing something that you don't know if it's going to lead to a pot of gold at the end or not. So to tie back to my earlier comments, that's why I would strongly encourage you to do a credit application. I think to the next screen, I want to talk about the benefits of an ongoing attorney-client relationship. First of all, a good attorney can help you identify avenues for collection that you may not know exist. For assets like automobiles and things like that. They're also, under Ohio law, there's something called fraudulent transfer claims, which means that if a debtor owes you money and he owned a house free and clear, but deeded the house to his sister or his wife, you would have the right to proceed with the lawsuit against the debtor and the person they transferred the property to wrongly. There's some elements you have to meet. You have to show that the debtor knew that he owed you the money and transferred the property for the sole purpose of escaping collection. There are also if you know someone who owes your debtor money, you also have the ability to pursue a claim against that third party for sums that are due and owing to your debtor. So if X business owes Joe Smith money and you have a judgment against Joe Smith, you have the right to get an order entitling X business to pay you what it owes Joe Smith. The other potential claims are what's called alter ego claims. That's when you have a small business where a client, where your customer has ignored the corporate formalities, meaning he has used his corporate checkbook to pay expenses that are normally not acceptable to be paid by the corporate checkbook, like his son's or daughter's college tuition, groceries, or things like that. Attorneys can help you identify claims where you have a claim against an individual as a result of the debts of a company. If you're also a company that does business with the general public, it's important to know that there's federal and state consumer protection laws that prevent you from pursuing collection in a certain format that's considered unfair by the federal or state government. And I'm skipping ahead. These are examples of unfair or deceptive and or abusive practices that are forbidden by Ohio or state law or federal law. Attempting to collect on a debt or charging interest that you're not permitted to by the law, falsely representing the character and amount of legal status of the debt, threatening action that is not intended and that you do not have authorization to pursue, taking possession of legal property without the legal right to do so, and revealing without the form of garnishment the consumer's debt to his or her employer. So under federal law and some state law, if you take some actions in violation of these provisions, you actually give the debtor the right to sue you for damages, as troubling as that sounds, or at least attorney's fees. So if you're in an area where you're not sure what you're doing with a consumer debt, then you should be talking to an attorney before you take legal action or begin the process of phoning and things like that. I also want to ensure, you want to make sure that if you have leverage, that you exercise that leverage as best you can. If it's a work product that you're developing, a physical structure, like a sign or something for a customer, I would not hesitate to, ask for a specific deposit up front. If it's something like that where you are in a construction trade and you're doing things, you need to look to whether you have a right to file a mechanics lien within so many days of the work being completed. I would not hesitate to ask for money to be produced on site as part of the original part of the program or your credit application, because times are tough and we all need to do what's fair and we need to be paid. So, I want to go back. In terms of the attorney-client relationship, one of the things you should consult an attorney about is when you have a debtor that goes bankrupt. Typically, you are prevented from doing collection when a debtor goes bankrupt. Until the bankruptcy stay is lifted. Typically, the case is stayed and you're not able to pursue collection. There is a procedure to file a proof of claim in bankruptcy court. And you may want to consider doing that. Years ago, I was taught that you spend the $100 filing the proof of claim, just in case something turns up in the estate and you get paid. That's always been my process, unless the client tells me it does not want to spend the money. Perhaps 10 years ago, I was representing the owner of a coffee shop that had been sold to a third party. The third party had defaulted on the lease. My client was still the guarantor, and therefore had to pay the landlord off. The operator of the coffee shop went bankrupt. As a matter of course, we filed a proof of claim. It was over, I think, $40,000, and nobody else filed a proof of claim. And we were lucky enough to I don't know how it happened, but the debtor eventually received some money that went into the estate. And being the only person that had filed a proof of claim, I was out of the blue received a check for $30,000 made payable to my client. And I was able to call my client and give him the good news out of the blue that I had a check for $30,000. So sometimes good things happen if you work hard. So to sum up, I believe that you should work hard to have a formal process and procedure with new customers, to identify who they are, what they are, where they do their banking, who they may do business with, so that if they do fail to make payments as promised, that you have the ability to collect as effectively as possible without spending good money after bad. If a client hesitates on a down payment, or hesitates to give you information about his business, I would not ignore that warning sign. We all want business, including attorneys, and we all are excited about the prospect of new business, but sometimes the warning signals should not be ignored, and there are some cases where you should walk away. So I'm going to check and see if there's any questions. Otherwise, I have completed my presentation. Thank you. Okay, there being no questions, I am going to complete my presentation. Thank you all very much for your time.